If you've ever bought land in Nigeria, or you're planning to, this one Supreme Court case could change everything you thought you knew about land ownership. For decades, we've all been told that before you sell, transfer, or mortgage land with a certificate of occupancy, you must get the governor's consent. But what if I told you that's not always true anymore? In the landmark case of Yakubu Ibrahim Ors v. Simon Obaje, 2017, the Supreme Court didn't just interpret the law, it redefined it. And the impact of that decision could save landowners and investors millions in unnecessary consent fees. Let's break down what really changed and what it means for you. Before we proceed, if you find this video helpful, don't forget to like, subscribe and share, and tap the bell so you never miss our next legal insight. Drop your comments below and tell us what topic you'd love us to cover next. Your suggestion could be our next video. For many years, it has been the settled practice in Nigeria that once a land has a Certificate of Occupancy, C of O, any subsequent sale, transfer, or mortgage of that land must first obtain the governor's consent under Section 22 of the Land Use Act 1978. In Savannah Bank v. Ajilo, the Supreme Court unequivocally held that, pursuant to the relevant provisions of the Land Use Act 1978 LUA, the governor's consent constitutes a mandatory prerequisite for any transfer or alienation of an interest in land within a state. The court further affirmed that non-compliance with this requirement renders such a transaction null and void. But a recent Supreme Court decision in Yakubu v. Omolade and Ors, 2017, has changed the legal landscape, and it's important that every landowner, buyer, and professional in real estate understands what this means. So, what does the Land Use Act say? Under Section 22(1) of the Land Use Act, it shall not be lawful for the holder of a statutory right of occupancy granted by the governor to alienate his right of occupancy or any part thereof, without the consent of the governor first had and obtained. This means that where a land is under a statutory right of occupancy, that is, has a C of O granted by the governor, the law requires the governor's approval before it can be sold or transferred to another person. Traditionally, failure to obtain this consent made the transaction void or incomplete. Coming back to our case review, what the Supreme Court said in Yakubu's case. In the Yakubu judgment, the Supreme Court made an important clarification. 1. The requirement for governor's consent does not apply to every land transaction. 2. It applies only to land still held under a statutory right of occupancy directly granted by the governor. 3. Where the land is private property, such as family land, customary land, or land that has already passed from the government into private hands, the insistence on governor's consent for every subsequent transaction is unlawful and unnecessary. The court also held that the requirement of consent and the demand for consent fees for registration of title documents between private individuals where there is no overriding public interest or conflict is unlawful and illegal. The Supreme Court's position now distinguishes between the nature of ownership and the stage of alienation. To clarify, 1. Once a land has been validly transferred from the original grantee, who obtained the governor's C of O, to a private person, and that transaction already had the governor's consent, the land ceases to be directly held under the governor's control. 2. It becomes private property, and subsequent private transfers of that land are no longer subject to Section 22's consent requirement, provided there's a. No public interest involved and b. No conflict between the parties. Let's look at what happens when a land with a C of O is sold. The information below gives clarification to the most common question among landowners and buyers today. Under the old rule, the new buyer must apply for the governor's consent to register the new deed of assignment. However, after the Yakubu case, the law can now be interpreted differently. 1. If the land has already become private property, i.e. no longer under direct government grant. 2. And the transaction is between private individuals. 3. And there is no public interest or dispute involved, then demanding the governor's consent or consent fees is no longer legally justified. So yes, based on the Yakubu decision, if 1. The original holder, A, got a C of O, 2. The first buyer, B, obtained governor's consent when buying from A. Then when B sells to C, C does not need to obtain another governor's consent to register the deed of assignment because the land is already private and the governor's supervisory role has been exhausted. What is the situation in practice? While the judgment is legally binding, most state land registries, especially in Lagos and Abuja, still insist on governor's consent before they will register your title documents. So, in practice, 1. You may still need to apply for consent to complete registration. 2. Even though the Supreme Court has clarified this, most state land registries, especially Lagos, still require consent before registration of any deed of assignment, irrespective of how many times the land has been transferred. 3. So, while legally you may not be required to obtain the consent again, administratively you'll likely be told it's required for registration. 4. But you now have a strong legal ground to challenge any excessive or unjustified consent demands, especially if the land is private and unencumbered. That means until the Land Use Act is amended or the Lagos State Land Bureau updates its process, you may still need to go through the motion to perfect title. Further validation of Yakubu Case is the Kaipi's case. The decision in Kip's case further reinforces the Yakubu precedent. In the High Court of Cross River State, the court held on 25th June 2021 that governor's consent is not required for transfer alienation of land between private individuals where there is no overriding public interest or conflict between the parties. The court went on to grant declaratory relief, obliging the state registrar to register deeds of assignment, conveyances, leases, mortgages, or other title documents in such private transactions without demanding consent fees. By doing so, the KIP decision gives practical meaning to the Yakubu ratio and shows how the judiciary is aligning procedural registration practice with the revised legal principle, thereby providing stronger certainty and relief for landowners and buyers in purely private land transactions. In conclusion, the Yakubu case didn't abolish governor's consent. It redefined its reach. What this means is simple. When land has already passed into private hands, demanding consent for every subsequent sale isn't just outdated, it's unlawful. Yet, until the Land Use Act and registry practices catch up, landowners still face unnecessary red tape. At Tonik Law Partners, we help you navigate this complexity, ensuring your property transactions are not only legally sound, but protected from avoidable costs and delays. For clear and practical guidance on land ownership and registration in Nigeria, contact us today at info@toniklawpartners.com or visit us in 22/23 Omotola Plaza, Allen Avenue, Ikeja, Lagos, Nigeria. Tonik Law Partners, legal excellence, practical solutions.